Good morning, everyone. My name is Catherine Angela Saldahena, your host for today. Thank you for joining us at another episode of Sprout HR and Legal Experts, the Sprout Solution. How are you? I'm sure this is a critical time for HR, and so we're here to give you legal and practical advice to help you lead your company from outbreak to breakthrough. Just to give you a brief introduction to who we are, Sprout is an HR technology company that helps your company take it to the next level in terms of taking care of your. We provide systems and support for recruitment, timekeeping to payroll, analytics, all in a cloud-based system to enable work from home for you. And now we hope to be able to help you lift your team during this crisis. While waiting for everyone to tune in, I'd like to introduce you to the raffle mechanics. So for the raffle, all you have to do is collect all three keywords that will be flashed on the screen throughout the seminar. Follow our official Facebook page at Sprout Solution PH. Comment all three keywords on the post pin on our page, and we'll announce the lucky winner at the end of the session. We'll be sending the Shopee gift certificate code through email after the session before 3 p.m. So for the first raffle keyword is strategy. Again, the first raffle keyword is strategy. So today we have very knowledgeable attorneys and consultants who are here to give you different tips on how to lead your company from outbreak to breakthrough. Prepare your questions for fireside chat session later and ask them anything on your mind with regards to matters concerning our topic today, which is business unusual, difficult conversation, and company right sizing. Without further ado, I'd like to introduce our first speaker, who has 12 years of human resource management experience at present. He practices the following fields of law: employment law, contract management, data privacy, administrative law, and family law as an advisor and an asset advocate. I'd like to welcome Attorney Lester Nazarene Ople.
Hi, good morning, everyone. I hope that everyone is safe and fully productive if you are working from home. And this is a topic that has come up during the past few episodes of this webinar. No, so we have been getting questions previously on the DOLE issuances. We were able to help our webinar attendees comply with the Labor Advisory 9 and eventually apply to the camp benefit of the DOLE. And we also did several other topics. And now that we are very, this is now the new normal, the social distancing, the enhanced community quarantine, and definitely businesses right now are very conscious of cost, no? And the labor cost, is something that is very significant these days. And you may get to a point that you need to think about right sizing. So today we will talk about right sizing. And when we were doing the content, we think that we can actually do 2 sessions on right sizing. No? So for today, we'll talk about right sizing, which really talks about the options available to companies when they think about a very difficult conversation, which is letting our employees go. Okay, next slide, please. Okay, so this is an excerpt from a case decided by the Supreme Court, Cebu Royal Plan versus the Deputy Minister of Labor. It's an old case, but it's a very timely reminder for our employers and business owners that the law really intends to protect our laborers, our workers, simply because our laws think that there is an imbalance of power. The employee is always placed under the mercy, quote unquote, of the employer, and our laws and jurisprudence is a testament to how our legal system favorably views the workers' rights. And this is a reminder that the law and the courts will always side with um, our workers' rights, but that does not mean that workers will always win in any labor dispute. This simply means that the law has placed very clear, very definite guidelines that employers must comply with in order to give the due process rights to our employees, meaning and reality. So please read this up. This is a very, I wouldn't read through the whole slide, but this is just a reminder that as we go through the content of this slide, of this presentation rather, we will be discussing the guidelines that the law and jurisprudence has established that all employers must comply with. And the moment that you comply with this in good faith, then definitely the law will and the courts will eventually you know, uphold that your exercise of right sizing is a valid company prerogative and you will not be penalized unduly. Okay, next slide, please. Okay, next slide, please. So what is right sizing? So right sizing is the process where an organization or a workplace restructures their whole organizational chart through reduction of workforce or reorganizing management lines. And the goal in any right-sizing exercise is to really get the company molded in such a way as to achieve maximum profit. However, in this ECQ, the short-term objective really is to protect the business by managing cost. And in particular, this is managing cost on the labor side of the equation. Okay, next slide, please. Okay, so the law, the labor code, has three sets of grounds for company-initiated termination of employment. So the first one definitely is very traditional. It's the termination of probationary employment. When an employee is hired on a probationary basis, there are two ways for the employer um, to let that employee go. The first one definitely is when there is a just cause for the termination of employment. And the more classic reason for letting go of a probationary employee is that the probationary employee failed to qualify as a regular employee. And the only requirement here is that there are reasonable standards made known to the employee at the time of his engagement, or at the very least, reasonably close to the start of the engagement. The second set of reasons is the just cause termination. And these are all embodied in Article 282 of the Labor Code. Some authors and some discussions would refer to it as Article 297. That is the renumbered Labor Code, but I'm an old school person. I stick to the original text of the law, which is PB 442. No? So these are the 5 grounds. So serious misconduct, gross and habitual negligence, fraud, commission of a crime, and lastly, analogous causes. These just causes are a subject fit for a separate discussion. So we will not be talking about just causes today. Rather, we will be talking about the authorized causes here, as well as the other options available to employers as you embark on your right-sizing journey. Okay. And then for authorized causes, it's in Article 283 of the Labor Code. It's closure of establishment and reduction of personnel. Another authorized cause is disease under Article 284. I've been seeing some questions on, we'll talk about that, Imam. We'll go to the next slide. Okay, so these are the 3 grounds in the labor code where an employer may validly let go or terminate an employee in unemployment. But that doesn't mean that you have to let go of employees simply to manage cost. No, there are other options available to you. So let's talk about this temporary closure of floating status as an HR action. No? The law allows this for a maximum period of 6 months. If you go by Labor Advisory number 9-2020, a temporary closure is actually one of the measures that the Department of Labor explicitly allows employers at this time during the ECQ. The only requirement here when you do a floating status is that you comply with the Labor Advisory 9-2020, which means that you have to comply and submit uh, an establishment report, a COVID establishment report, and submit it to the DOLE regional or provincial office that has jurisdiction over your workplace. One more thing about the temporary closure or floating status, um, you know, you have to do this in good faith. If your business is, for example, in hospitality or restaurant industry, or another business that is adversely affected because of the community quarantine, then you are definitely experiencing either low demand for your product or service, or you are having trouble securing the raw materials for your production. So in these cases, temporary closure or floating status is definitely allowed. Okay, now let's talk about reduction of hours or days worked. This is another alternative work arrangement where you reduce the number of work hours or work days of the employees. Again, you have to comply with Labor Advisory 9-2020 and submit a duly accomplished COVID establishment report form. This is when you actually reduce the salary of the employees corresponding to the number of hours they are actually working. So this is different from simply imposing a pay cut. When you impose a pay cut, that actually violates the principle of diminution of benefits. You're doing diminution of benefit, and that is prohibited under the labor code. But if you do reduction of hours or days work, that is perfectly legal under Labor Advisory number 9-2020. Because the Department of Labor acknowledges that the ECQ is, it's a temporary situation. We hope it is a temporary situation, and having everyone reduce the hours or days work and correspondingly decrease the pay that will be given to the employees is more preferable than actually closing the business. Okay, next would be the rotation of employees. This would be a case that you have, for example, a production line of 100 employees. Your production is on an 8x5 basis. So for 8 hours a day, 5 days a week, you have 100 employees working the production line. Due to the COVID ECQ, you are now forced with reduced market demand as well as a reduced accessibility to your raw materials. And you can reasonably provide work only for half of your workforce. Pero 8x5 pa rin kayo. This is an instance where you can actually do a rotation of employees. So for week 1, for example, you have employee 1 to 25 working, and then week 2, employee number 26 to 50, and so on and so forth. Just so during the period of the ECQ, equally distributed yung workload, number 1, and number 2, the pay to your employees, so that, again, the intent is to prevent or avoid a situation where you're actually closing your business. Okay. Next would be the forced leave. This is very contentious. In our previous webinars, there has been a lot of questions on the forced leave. And what we want to impress on the forced leave is that, number 1, it's allowed under Labor Advisory 9-2020. And instead of, this is a situation that your company is actually closed and nobody is reporting to work. But you allow your employees to use sick leave, vacation leave, or any other paid leaves available to them according to your company policy or contract, so that they are actually paid even if they are no longer working. Remember, our labor code, the general rule on pay is really no work, no pay, regardless of the basis of payment. If you are monthly or daily paid, general rule pa rin is no work, no pay. So if you did not do productive work, you are not actually eligible to receive pay. Unless, of course, you have leaves that you can use and apply during the period of the ECQ. So ang isang contention dito is that, can an employer actually force an employee to use the leaves? Actually, misnomer yung term na forced leave, no? Because again, it is the employee's option whether or not leaves will be used by the employee. Pero ito naman yung caveat doon. The employee cannot also force an employer to get pay even if hindi siya nag-work. That is why it's called the forced leave kasi nagkapwersahan sa sitwasyon na magli-leave na lang tayo as employees para si employer magbayad and then si employee gagamit ng leave. No, so it's not ako si employer sasabihin ko, oh, i-apply niyo yung leaves nyo. It's not that way. It's, guys, we are closing the business. You are allowed to use your leaves. Do you want to use your leaves so that you will get paid during the ECQ? Or you go to the regular na no work, no pay scenario? Okay. So I saw a question which I will advise. No, it's the Labor Advisory 9-2020 that really is intended for COVID response. No, after the COVID period, there are two possibilities. Number one is you may go back to your original situation, in which case you just notify your Department of Labor provincial or regional office that you are resuming work on a regular basis. And then the other one is magkakaroon tayo ng subsequent issuance by the Department of Labor pertaining to the new normal. No? So I'm hoping that the after the ECQ is lifted, we now have a new normal. So I'm hopeful that the government will actually be issuing new issuances to guide us on legal compliance as we navigate the new normal. One more thing about Labor Advisory 9-2020. Again, the general rule in the Labor Code is for yung temporary closure or floating status, it is allowed for a period not exceeding 6 months. So if you think that you are actually still suffering from reduced market demand or reduced access to raw materials even after the ECQ, it is an option available to you provided you do not exceed the 6-month period. Another question here, another possible question. Yes, I saw that question. To have a mix of the different options. Yes. What would be sticky here would be you would have the option of doing multiple reports, COVID establishment report forms. No? For example, you're a large organization. You have 5 branches. Each branch, excuse me. Don't worry, I have no fever. Excuse me. Okay. So the question here is, can you do a combination of right sizing options? My answer is yes. I will admit though that the Labor Advisory 9-2020 is silent whether you can do a combination, but my submission is yes, you can do that. Why? Because you may be a large organization, you may have several branches or several workplaces or work sites, and depending on the complexity of your operations, you may need to avail of separate HR actions as you go through your right sizing exercise, okay? Some other questions, we'll address it later, but for now, let's go to the next slide. Okay, another option here is, I put it here, it's retirement. No, your ordinary retirement is that somebody hit the retirement age established in your contract or CBA or other, employment policy. Some companies may have the financial capability to offer an early retirement program. No, so in which case you will offer a retirement program to your employees and then let people avail of it, provided they meet certain criteria. So what happens in a retirement scenario? You have to ensure that your retirement benefits that you give to your employees is not less than what is provided for by law. So this is an instance that, when we go back to the new normal, it might be a very prudent exercise for us as employers to check whether we have the financial capability to offer a retirement program, or the other option is to invest in a qualified retirement savings program with a partner bank. So those are two options that you may explore. What is important, however, in a retirement is that you have a policy that applies to all or to a very uniformly identified set of employees. Companies, I'll name drop some companies. So companies like PAL, San Miguel, these are big enough companies and they do offer early retirement as an option. I do know that they did offer retirement options to their employees as they went through their right sizing programs. Okay. And then you also have the redeployment or transfer of personnel and retooling or change of job tasks of personnel. No, these are instances that ordinarily you do not think of them as options when you do a right sizing, but this is an exercise of management prerogative. If you do this in good faith, meaning there is no negative intention or ill will directed to a particular employee or employees, you may validly, shift them around. For example, you may want to, if you're a sales organization, pwede niyong gawin na check your sales districts and see if you can actually work with less people in a district and then spread people around in other parts of the organization, maybe finance, maybe a shared service, a small shared service department, things like that you can explore. But the important thing here is that you support your employees as you go through these kinds of management prerogative exercises. No? Meaning, when you do a transfer of personnel, you do it, you communicate it well and provide the support necessary so that when there are associated costs with a transfer, hindi naman na mafe-feel ni employee na napabayaan siya na nasa Maynila ako, nire-assign ako bigla sa, let's say, Cebu. And then there's no other option but I just have to take it. No, let's not put our employees in a spot that it is preferable for them to just voluntarily resign, because that actually exposes you to a risk called constructive dismissal. Okay. One more thing would be, again, on the change of job tasks or of personnel, you may want to increase the number of direct reports for your managers, and then change the job profile of certain managers so that hindi na sila people manager, they are now individual contributors, but doing a more valuable or a more cost efficient work. Okay, now let's go to the next slide. Okay, this is your second raffle keyword. The second raffle keyword is legal. So I hope you were able to take note of the first raffle keyword. This is now the second keyword, which is legal. Okay, next slide, please. Letting go. I have this running joke with my former team members whenever we let people go that I have this song. Is it an Ella May Saison song? There's someone's always saying goodbye. I think that's the title of that song. I can't sing, so I will just mention the title. Okay, let's go to the next slide. Trying to make a light moment. Okay, now let's talk about the just and authorized causes. So earlier, what we were able to discuss are the options available to you in a right sizing exercise. So when you do this right sizing exercise, kasi, it's very simple to comply with. You just, for example, those options available to us in Labor Advisory 9-2020, simple lang mag-comply. You go to your COVID establishment report form, fill up the necessary data fields, and then submit it via email to your DOLE provincial or regional field office, your SEP. No? But with just and authorized causes, you have very specific guidelines that you have to comply with so that you avoid legal risk of getting into a labor case. No? So let's just compare very quickly the just cause and authorized causes of termination of employment. So for just cause, there are only 5 grounds: serious misconduct, gross and habitual negligence, fraud, commission of a crime, and analogous causes. I include as a just cause yung probationary employee who fails to qualify as a regular employee, but take note that that is a separate ground. No? Okay. And then for authorized causes, these are the grounds: no? Redundancy, closure of establishment, installation of labor-saving devices, and retrenchment. I also included here as a ground for an authorized cause, disease. We'll discuss the details of these grounds later. Now, as to eligibility for separation pay, ito yung pinaka-importanting hinahanap ng ating empleyado. When you do a just cause termination, the general rule is a just cause terminated employee is not eligible for separation pay unless your company policy or employment contract explicitly provides for benefits regarding a terminated employee. However, in authorized causes for termination of employment, these are all eligible for separation pay, and non-payment of separation pay will incur legal risk on your part as an employer. Okay. Now, as to the due process requirements, just causes of termination require what we call a twin notice rule. Briefly, this is explained by the Supreme Court in the case King of Kings Transport Inc. versus Mamak. It's a 2007 case. I remember this very distinctly because this was part of the bar, I think, when I took it. So the twin notice rule is embodied in King of Kings Transport versus Mamak. And for the probationary employment, the due process requirement is that there must be standards of regularization communicated at the start of the engagement. Now, for authorized causes, the only due process requirement is that you have a notice to the employee and to the DOLE, and in the case of disease, a certification from a public doctor. We'll go through the authorized cause details in a few moments. No? So I've seen some questions about the amount of the separation pay. We have a slide-by-slide discussion on the separation pay due for each instance. Okay, next slide, please. Now, I want to harp on this and make sure that everyone is very aware of what the procedural due process is required in authorized cause termination. First one, you have to have a service of a written notice to the employee and to the appropriate regional office of DOLE at least 30 days before you terminate the employee. Okay. Second, your ground availed of must be specified. Hindi pwedeng yung notice natin, you're being terminated for an authorized cause effective 30 days from now. Hindi pwedeng ganon. You have to be very specific in the notice as well as in the report to the DOLE regarding the ground that you're availing of. No? So here's, this is the title of the form. You can download it on the DOLE website. It's called an RKS Establishment Termination Report Form. And the notice, the general rule is that it must be personally served to the employee and duly signed by the employee. What happens if the employee refuses to receive or to sign? First one, pakiusapan nyo. In terminating an employee, it is very much preferable to do it face-to-face. Bakit? It's a difficult conversation, but you're able to have a human-to-human communication regarding the reasons why you are doing this. And when you actually go to the text of the labor code, ang preference talaga is personally received by the employee, personally served to the employee yung notice. Some practitioners actually do registered mail, no? That is only a supplementary application of the rules of court, because again, if you do not have, or rather, if your employee refuses to receive, you can actually opt to serve it via registered mail with a return card. The DOLE actually acknowledges that and stated that rule in Department Order number 147 series of 2015. No? So all of the content of this lecture is actually drawn from Department Order 147-15. And in case that there is no personal service done, you may opt to avail of registered mail as an option. Pero again, the preference here is personal service, harap kayo, and then pakiusapan yung tanggapin niya. Bakit niya kailangan pirmahan? Kasi it's actually the fact na kailangan nyo lang siyang i-personally serve, kaya nyo kailangan ng pirma ni employee. No? And then explain to him or her that if he insists on refusing, then you will have to do it via registered mail. Question, can we do it now during the ECQ? This is a sticky topic. Why? Because ECQ means na hindi kayo pwede magharap-harap. No? So if you opt to avail of personal service, you actually have to go to the employee's house and then serve the notice. And it's very difficult for somebody who's in HR or in legal for that matter, going to the barangay of an employee. Unang-una, baka hindi ka papasukin. Pangalawa, baka hindi ka makalabas. yun yung mga challenges natin sa termination in this period, no? So while we're talking about the procedural due process when terminating an employee, the important thing here is that we're doing this on an educational basis, but you may actually avail of the other options, particularly the temporary closure in your case. Kasi ang objective naman natin sa ECQ is to prolong the life of the business and to prolong employment for as long as is reasonably necessary. If you go by last episode, or is it the other episode, Attorney Ryan Trinidad was able to discuss the other aid programs of the government, particularly the small business wage subsidy. Now, if you cut off the legs of your employees at this stage, that makes them ineligible for the small business wage subsidy, while at the same time, places them in a predicament na wala naman silang income, tapos na rin yung period ng application ng CAM. So, alam mo yun, parang sobrang hirap on the part of the employee to actually now go into a mode na mag-aasa siya ngayon sa charity. No? So, you may go with email service, but again, what does your policy state? If your policy does not allow for, or if you have no policy at all, then it is the law that will apply. And the law is very clear. It has to be personally received or signed, or in the alternate, registered mail. Kung wala kayong policy that states email service is acceptable, then you are definitely barred. No? Bawal po kayong mag-serve ng notices na ganito via email if your policy is silent regarding service to employees via email. That is the conservative view. And at this stage, I exhort our attendees to stick with the conservative view because when the courts reopen, when we all go back to normal, employees will have a period of 4 years within which to question the termination. Okay, so I cannot emphasize this enough. Please if you do not have a company policy that says communication of notices on termination of employment or personal actions is allowed to be done via email, then don't. Go still with personal service and registered mail. Okay? Okay, let's go to the next slide. Okay, so every ground in the labor code has requisites that you have to comply with so that you are actually availing of that ground. So in particular, for installation of labor-saving devices, we have 5 requisites. Number 1, there is an actual machinery, equipment, or other device introduced in the workplace. Such introduction was done in good faith, and the purpose of that labor-saving device is to save cost, enhance efficiency, or there are other justifiable economic reasons. And there is no other option available to the employer other than such machinery. And lastly, there is a fair and reasonable criteria in selecting employees to be terminated. As to the separation pay, it's 1 month pay or at least 1 month pay per year of service, whichever is greater, and you treat a fraction of 6 months as 1 year. Okay? So what is very important when you avail of the labor-saving device as a ground for termination of employment, good faith. And may machine talaga or equipment or other device. Question, is automation included in a labor-saving device? My submission is yes. When you go by the legislative history of the labor code, this was done when we were still in a very industrial era. Manufacturing pa rin yung primary na economic activity at that time, manufacturing and agriculture. So when you talk about labor-saving devices, during the time that the labor code was crafted, these are the automated mills, robotic machineries. So yung artificial intelligence and other software-enabled na devices or interventions, wala pa yan nung time na yon. But because now we can have AI to replace certain human activities in economic activity of the workplace, then it is possible to use this ground when you introduce software or artificial intelligence or some other non-tangible improvements into your business. Also, the fair and reasonable criteria. Hindi pwedeng ang gawin dito is, ito, ayoko nitong taong to kasi may attitude problem. Pero kung tinignan mo yung 201 file niya, wala naman siyang history of disciplinary action. You just don't like the guy. Please do not do that criteria when you select employees to be terminated. It has to be logical. For example, you installed a machinery in a production line and then ang ita-terminate mo, yung QA. Medyo mali po yun. Okay? And also separation pay, I cannot harp this enough. You have to pay separation pay. Okay? Next slide. Next slide, please. Redundancy. Now, redundancy, ito yung meron ng superfluous position or excess na yung headcount natin. So when you have a superfluous position or service of employees, and then it is already in excess of what is reasonably demanded by the enterprise, and then of course, good faith, fair and reasonable criteria in selecting employees to be terminated, and adequate proof of the redundancy, you are allowed to avail of this ground when you do an authorized cause termination. Separation pay of 1 month or at least 1 month pay per year of service, and again, a fraction of 6 months considered as 1 year. Let me go back to comparison between labor-saving device and redundancy. When you do an introduction of a labor-saving device, direct yung impact. Meaning, ito yung machinery na install mo dun sa production line, yung taong nandun sa manual, previously manual process na yon, dahil may makina na gumagawa ng trabaho niya, siya yung installation of labor-saving device. Now, when you do something like may inintroduce ka na machinery, and then yung operator doon, ni-retool mo para siya yung operator na ng machinery, hindi na siya manually. For example, your business is soap bar manufacturing. So instead of a manual cutting line, you now have an automated cutter. Instead na pinuputol ng kutsilyo, ginagano na lang yung lever and then it automatically cuts the bar soaps. When down the line, dahil nagkaroon ng efficiency gains yung production line mo, nakita mo na ay sobra na yung cutters mo. Yun na yung tinatawag na redundancy. Hindi siya immediate. When you talk about installation of labor-saving device, then it is immediate. But when you talk about redundancy, this is more overall, more holistic. And again, what is required here is that there is good faith in abolishing a redundant position. Another point, when you do a redundancy, or rather when you do other HR actions such as reassignment, redeployment, or retooling of your employees, you may get to a point that you can see that some of your people are actually not doing anything anymore. For example, your business is a BPO. One of your services is document management. And then when you do document management, dati manually titingnan yung dokumento, i-encode yung contents ng document na this is the subject line, ito yung metadata tags nyo, tapos biglang naging automated yon. No? So you now have a redundant situation rather than an installation of a labor-saving device na position. No? So there's a very thin line separating labor-saving device and redundancy. But as a general rule, pareho lang po ang effect ng redundancy at labor-saving device in terms of separation pay. And also, pareho din yung requirement in terms of good faith, reasonable criteria, and proof na meron talaga kayong efficiency gains or superfluity in headcount. Okay? So, academic po yung if we go by a very strict academic discussion on redundancy and labor-saving device, hindi na practical yon. So, let's just go with, if you install a device directly and then somebody is directly impacted, you call it an installation of a labor-saving device. But if you do something else and it's somebody else in that production line who is affected due to the efficiency gains, you call it a redundancy. Okay. Next slide, please. And we talk about retrenchment or downsizing. This would be, we're hopeful that the slump in economic activity will not result in massive retrenchment and downsizing of the economy. But when you do reach a point that your business really has to do this, these are the elements. Retrenchment must be reasonably necessary and is likely to prevent business losses. Losses if already incurred or substantial, serious, actual, and real, or if expected, reasonably imminent. Expected or actual losses proven by sufficient and convincing evidence, again, good faith and reasonable criteria. Ang difference po dito is separation pay of 1 month or at least half-month pay per year of service, whichever is greater. So kanina, dahil kumita yung employer, may ganansya or may efficiency gains si employer, ang requirement sa kanya is 1 month pay per year of service. Now, dahil nagpe-prevent ka ng losses, excuse si employer from paying a huge amount of separation pay, and you're only required to pay half-month pay per year of service, whichever is greater. Okay? But let's talk about two scenarios here when you talk about retrenchment or downsizing. Actual loss at saka imminent loss. Ano yung actual loss? Actual loss is naubusan talaga kayo. I mean, financially, naubusan talaga ng revenue or nag-zero revenue yung kumpanya. And you expect that it will be that way for a significant amount of time after. So in that case, dahil financially at a loss si company, you may actually retrench or get, identify people who will be downsized. The important thing here is that you are able to substantiate the losses. Now, when you talk about imminent losses in a retrenchment exercise, ito yung tinatawag nating foreseeable event. For example, way back in the 90s, we were heavily a garments exporter. When certain tariff restrictions were lifted, some of the manufacturers who are based in the Philippines saw that it would be cheaper to move production into places like Vietnam, Cambodia, China, and as a result, they closed most of their factories. Now, since foreseeable yon, may effectivity date naman yung pagpirma natin ng tariff agreements at that time, yun na yung proof mo na meron kang imminent losses that you have to avoid. That's why you are now retrenching or downsizing. Okay. How about COVID? How about the ECQ? Ito po yung wala po tayong nakikitang imminent. Actual na po ito. We are now in the middle of the ECQ. Economic activity is all but halted. So you cannot use the imminency option in a retrenchment. You are expected to use the actual losses na option. Ano yung evidence to prove actual losses? So you have your revenue statements, your balance sheet, your financial statements. The preference is audited financial statement, but with the current situation natin right now, your audited financial statement may not readily be available. So ang ano dito is you now go with duly documented balance sheets or revenue reports. Basta ang importante dito is kapag kinailangan, you are brought to court for a labor dispute because somebody is questioning the legality of your retrenchment or downsizing exercise, you have duly dated and documented evidence that you can present in court to show that you are actually experiencing losses. Hindi pwedeng Excel file na gagawin nyo lang kapag nagkadalahan na sa korte. I-date nyo yung report, pirmahan nyo yung report, and then make sure that these records are kept safely so that you can actually bring them to court in the event that you have a labor dispute because of a retrenchment exercise. Okay? Let's go to the next slide. Disease. Now, when you talk about disease as an authorized cause of termination, ito yung tinatawag nating highly contagious or heavily communicable disease that cannot be treated within a period of 6 months, even with proper treatment. So these are conditions such as tuberculosis, what else? Stroke, basically anything that would be prohibited by law or prejudicial to the health of the employer or health of co-employees. The requirement here is that there is a certification by a public health authority that the disease is incurable within a period of 6 months, even with proper treatment. Anong meron sa public health authority? This is simply a government doctor. Pero may requirement pa yung batas dito. The public health authority should be relevant to the disease. For example, an employee is deemed to be at a late stage tuberculosis patient. And then, despite complying with government guidelines on pulmonary tuberculosis treatment, naka-paid leave na siya, hindi pa rin siya magagamot. And the doctor deems na magiging communicable pa rin siya if ibalik mo siya sa opisina, risk siya sa ating co-employees. So, yung certification ng Public Health Authority, hindi po pwedeng gastroenterologist. Kailangan po pulmonologist kasi the disease is talking about, a pulmonary disease, but the Public Health Authority is a different discipline or a different specialization. Hindi po maaaring i-accept yun. Can we go with a general practitioner, a family medicine practitioner? My take there is it would be a case-to-case basis kasi can a general practitioner or a family medicine public health authority actually certify regarding the incurability of this disease? No? So yun yung magiging question ko sa inyo. Because of the disease, there's a separation pay requirement as well. It should be 1 month pay or at least half-month pay per year of service, whichever is greater. And again, 6 months considered as 1 year. Okay, let's go to the next slide. Closure, cessation of business. Ang pinag-uusapan po dito is not the temporary closure which I discussed earlier na not more than 6 months. The closure here is a total closure of the business. So it only happens when you have a decision to close or cease the operation. There is good faith. Hindi pwedeng, nagtayo ng union yung mga tao, isara natin yung negosyo. Hindi po pwede yun. That's a separate offense that can be considered an unfair labor practice that's punishable under the labor code. So it has to be good faith. This would be things like, it's a family corporation, the patriarch has passed away, and the children want to partition the business. That is definitely a good faith exercise of the closure. Lastly, kailangan mapakita natin that there's no other option available. Again, the separation pay here is half-month pay per year of service, whichever is greater. And take note, kung serious business losses or financial reverses, ito po yung sole instance ng authorized cost termination na walang separation pay required. Ano yung serious business losses? Ito yung nasa near bankruptcy or bankruptcy situation ka na, the company has no other way to pay its employees other than the sale or disposition of its assets. Ganun po yung serious business losses na kino-contemplate ng batas. Hindi po yung simpleng, walang benta. No? So hindi po ganun yung serious business loss na kino-contemplate ng ating batas. Okay? Let's go to the next slide. Okay, so I would be closing my discussion with this excerpt from another Supreme Court case. This is a just cause case. The employee was terminated for a just cause, not for an authorized cause. But I think this is very much in consonance with my earlier Supreme Court excerpt, which talks about how our legal system favors the employees heavily. So again, this is a reminder that the grounds that we avail of whenever we terminate an employee must be serious and grave to justify the deprivation of a means of livelihood, because our laws actually favor the working class and mandate that every doubt must be resolved in their favor. Meaning, kung pantay lang ang level ng ebidensya natin sa labor dispute, ang likely mananalo doon would be the employee. That does not mean to say na laging papanalunin ng labor courts ang employees, but it only means to say that we as employers are held to a higher standard of compliance with respect to compliance with due process, both substantive and procedural, when we terminate an employee. So it's very important that we document everything, and then of course, let's not remove the human component, and let's treat our employees with compassion. We may need to let them go, but if we let them go in the most human, humane, compassionate way possible, then possible naman na hindi natin ma-encounter ang labor dispute. Okay. I turn it over back to Kat.
Thank you, Attorney Lester, for the informative talk po. So I'd like to announce the third raffle keyword for today. So our third keyword is company. So to recap, the three keywords are strategy, legal, and company. So join the raffle by following our Sprout Facebook page and commenting these three keywords on the pin post. So the next portion of the event is our fireside chat. So prepare your questions and just type them in the chat box. I'd like to welcome back our speaker, Attorney Lester. For our second panelist, let's welcome Ray Salvador, our seasoned audit and risk management professional with 9 years of experience from various industries. He is a certified public accountant and ISO certified lead risk manager. Also, our third panelist, Attorney J. Ryan Trinidad, data privacy officer and HR and legal consultant of Sprout Solutions. He has previously worked in reputable law firms and private companies as a labor and tax lawyer, counseling mostly for HR practitioners and company management. J. Ryan helps companies address intricate HR and legal issues. Ladies and gentlemen, you can start asking your question using the Zoom chat. So for our first question, what's the treatment for the holiday pay of employees under reduced work hours? Should it be deducted in terms of hours as well?
Sorry, I didn't get the question.
Sorry, to repeat po, what's the treatment for the holiday pay of employees under reduced work hours? Should it be considered deducted in terms of hours as well?
When you talk about holiday pay, this is in Article 94 of the Labor Code. Ang eligibility for the holiday pay is, if you are not a government employee, not a managerial employee, or your establishment is not employing 10 or less employees regularly, the general rule is eligible yan sa holiday pay. Ano yung basis ng holiday pay? It's actually hours worked. No? So if you have holiday pay, or rather if you have worked on a holiday, particularly, I'm guessing this is April 9 and April 10. No? Iba yung factor dyan sa April 9. April 9 is a double holiday. So the rule there is it's 300% of the daily wage if worked, 200% if unworked. As long as the employee is eligible for the holiday pay under the labor code and relevant employment policies. Now, if you reduce your work days by hours only, that means na yung proportionate pa rin, no? So kung ang hourly rate niya is kung ang daily rate niya rather is, ang hirap nito math, it's 1,000 yung daily rate niya, and then that's for an 8-hour work shift. Bawasan mo ng 2 hours, that's an equivalent reduction of about 25%. You now deduct the 25% or the 250 pesos from the daily rate, and then you still apply the multiplier, which is in the event na unworked 200%, if worked 300%. Ang magiging tanong dito would be overtime. Would an excess time worked? So nag-shorten kayo ng hours, 6 hours na lang. Yung 6 hours na yun should be paid 300% kasi yun yung double holiday rule. Pero nag-extend siya, naging 8 hours pa. So dapat bang maglagay ka ng premium dun sa 6th hour to the 8th hour? My submission is no, kasi naka-reduced work hours ka na. You just pay the full daily rate, which is 1,000 pesos ulit, and then you apply the same multiplier. Pag nag-exceed ka na lang ng 8 hours, dun ka lang mag-pay talaga ng overtime rate. You know what? Let me, at this point, no, this actually becomes a lot easier if you have timekeeping software like Sprout. And at this point, I'd like to share that we are offering the Rescue Kit. The Rescue Kit is for a period of 60 days, totally free yung ating timekeeping and payroll software for our qualified small business colleagues. And please get in touch with Kat if you are interested to avail of it. So these questions would be very easy to resolve if you have timekeeping and payroll software like Sprout.
Kat, may I also add on that? So, one way to address these holiday issues is for them to get updated on the latest advisories of the Department of Labor and Employment. No, Dole regularly updates its website, so feel free to check their websites every now and then. No? But if you really have questions, because there are a lot of nuances on the implementation of the holiday pay, so you may want also to contact the Bureau of Working Conditions. They are still on a skeletal workforce right now, even during this ECQ period.
Thank you, attorney. So for the next question, how can you track workforce attrition during work from home setup?
Yep. The attrition is something that you as a previous I don't know in a previous life I'm an HR manager as well. So this is normally manually tracked via Excel. No, so you have a total number of employees in your Excel file or employee database, and then you manually remove them or tag them as resigned, and then you report it on a monthly basis. I think the regular process of tracking attrition still applies, but if you have tools like Sprout nga, it's very easy to just run reports. The important thing is you have somebody actually managing the reports or actually managing the employee information in your system, whether it be a manual system or an automated system like Sprout.
Next question. With forced leave, can companies assign forced leave even if they do not have paid leaves anymore? Meaning it's forced leave, unpaid leave?
Ang tawag na po doon unpaid leave. Ang ano natin doon is when these cases kasi would have to regularly parang wala naman siyang effect, no, if you only talk about labor compliance, kasi malinaw naman the general rule in the labor code is no work no pay. However, these compliances that we are endorsing everyone to comply with now matters when we talk about the small business wage subsidy and other government aid. So it is very important that we track and report these correctly. In that case, no, that the employees have already run out of paid leaves, if it's across the organization, then it might be more prudent to simply tag that as a temporary closure of the business, do the corresponding report with the DOLE, and then submit the same so that the employees may become eligible for the small business wage subsidy of the DOF.
Thank you, attorney. So next question is, may I know if a regular employee will still accrue leaves while on floating status?
Sorry, is that while on floating status?
May I know if a regular employee will still accrue leaves while on floating status?
Floating. Actually, that depends on our company policy, no? Remember, the temporary closure of, or rather, the float status does not mean that the employee is terminated. No? So, if your company policy clearly provides na even during a float situation, mag-a-accrue pa rin siya ng leave, actively employed pa rin yun eh. But if your policy is in such a way na kailangan actively reporting siya, no? And if the employee is not actively reporting, the person does not accrue leave, then that's you just apply that regular rule. Again, this is an instance that software and tools like Sprout can actually help because automated po ang ating accrual sa ating Sprout timekeeping software. So please, if you are having these questions and please avail of the rescue kit because for a period of 60 days, and our CEO actually committed na hanggang hindi pa nalilift yung ECQ, he will continue with the rescue kit program. Please avail of it so that you will see how convenient it is for an organization to actually have a timekeeping software like Sprout.
May I also add, Attorney Lester, no, that you're right there to say that they have to check their company policy because if you are already providing this to your employees, even if they are in the floating status, no, this might already ripen into a company practice, no. So hindi na agad natin siya pwedeng i-withdraw dahil that would basically become a diminution of benefits of these employees whether they are in a floating status.
Thank you, attorney. So next question. With the work from home setup, it's hard to track attendance and productivity of employees. Do you have any tips on this?
I'm deferring to Attorney Ryan. Attorney Ryan is leading our legal department at this time. So I think
Well, yung
Attorney Ryan,
Sprout
go ahead.
itself, yeah, the system is very useful, no, for us. Kasi we can check the attendance by using our system. Our employees can actually log in and log out, no, using a web bandy or even our mobile application, no. That's one way of checking if they are in attendance or present, even in the work from home arrangement, no. And at the same time, internally we have our regular monitoring where we check on our employees, and we request them to provide us about their deliverables every day. So what we do is that every morning, immediately after around 9 in the morning, we will do our DSM or our daily stand-up meetings where we will tell to each other what we are supposed to deliver for today and what we did for yesterday. So those are some of the ways that you can do to check the productivity of your employees during this COVID time. No.
To add also, with regards to checking the attendance or to the daily stand-up meeting, we can also use free applications. Like for example, if you are using the Microsoft applications, you can use the Microsoft Teams to do your daily meetings, as well as yung for Google naman, they have Google Meet to do your team meetings. So you can check the status of your employees at the same time, use their emails as well to gather the output for that day or for the certain period. And also, as noted earlier, Sprout currently is offering the rescue kit, which is free for 60 days. So they can avail this time attendance application as well as for the payroll then. So for now, there are a lot of free applications that they can take advantage of.
May I also add, Attorney Lester, no? So one of the problems that we are facing right now is that a lot of our employees are asking how we can help them financially, no? This is one of the concerns that we normally get from them. So at Sprout, what we have is our InstaCash, where our employees can easily get, in a matter of few minutes actually, or 2 minutes, no, can get a loan from our system, no? Previously, it was only 12,000, but now I believe it's already raised to 25,000. And another issues that we have are, the mental concerns of our employees. So ang ginagawa natin, palagi tayong mayroong mental health awareness programs. We do it via Zoom. So this is how we help our employees during these very trying times, no?
Thank you, attorney. So for the next question po natin, allowed ba to have a mix or combination of different options for right sizing in one company? For
Yes.
example, okay pa.
Yeah. I think in terms of you may be in a workplace or in an organization that has multiple work sites. For example, you are a pawn shop na maraming branch, or a bakery na maraming branch, no? So you may have a situation that different areas have different applications, no? So if you go to the text of Labor Advisory 9-2020, if you are a multi branch type of employer, kung saan yung main branch, doon kayo mag-submit. Pero if meron kayong intricacies, like for example, some areas like in Rizal province, there's total lockdown, no? So employees who are residing outside of the Rizal province may not necessarily be able to come to work if their workplace is in Rizal, no? So this is a case that you might want to explore a temporary closure for certain branches or certain workplaces. So it is not prohibited to mix. What is important, however, is that you ensure consistency, fairness, and reasonableness when you choose which option to avail of in this toolkit.
That's correct, Attorney Lester. No, it's not illegal to mix, but of course you have to consider that yung right sizing nyo is very important for the success of your organization. So you have to understand how the size will impact this your productivity, also yung structure ng organization nyo and design of the work. So I think one good way to deal with that is for you to have a metric-driven, assessment of how you will do your right sizing. And I believe Sprout can help you with that. We have our own insights that can provide you specific data that you will be needing for you to decide on your right sizing schemes.
Thank you, attorney. So For Article 286, when employment not deemed terminated, is there a requirement here to provide a 30-day paid notice for people when using, or is this just a business practice? I don't see any letter in the law that requires it.
That is correct, no. In real practice, no, this float option is really availed of by the security agencies. When you have security guards who are in between projects, ang tawag doon float, because employment is not interrupted. What matters here is that it's very clear to the employee that he or she is being placed on a float. How do you do this? You may have a letter or a personal action letter or a notice that tells simply the person that yung project mo or yung kliyente mo, kung ikaw, security agency ka, no, nag-end na yung contract natin, you are recalled back to the base pending the identification of your new assignment. As simple as that notice, makaka-comply ka na. There is no 30-day notice period requirement. But may caveat ako doon. If you have a company policy that states that you want to do that, then you have to be held to a higher standard because you provided in your company policy that you will observe a 30-day notice period before you provide such a notice to your employee.
Thank you, attorney. So that's all the time we have now for our panel session. For the questions we weren't able to answer, please email legal@sprout.ph. So thank you for everyone for participating. And thank you, Attorney Lester, Ray, and Attorney J. Ryan for your inputs. So now, for the moment we've all been waiting for, I'd like to announce the 4 raffle winners. So our raffle winners are Ginger Santos, Aisel Juho, Chris Cañete, and Richard Tan. Again, our 4 raffle winners is Ginger Santos, Aisel Juho, Chris Cañete, and Richard Tan. For the winners, please type your email address in the Zoom chat box so that we can send you the GC codes through email. And thank you everyone for participating. We can also send you e-certificates for attending this session. Here are the instructions on how to get them. All you have to do is email info@sprout.ph for attending this session and then indicate your name, full name, company, and position. Follow us on our social media page and use the hashtag OPWithSprout to be updated on our events. See you on our next webinar on Tuesday next week.